We are live.
All right, good morning and welcome to the House Environment Committee. This morning, we are going to start by discussing an amendment on H 86 from our Appropriations Committee with Legislative Council.
Good morning. This is Mike O'Grady with Legislative Council. Yesterday, Representative Chapin and I went into House Appropriations on H 86. Honestly, before we even got in there, we were told to draft an amendment that would take all of the appropriations out of the bill and make the bill contingent on receipt of appropriations. So that is what you will see in front of you. It repeals section 6 of H 86, which was the appropriations, and in its place puts in a contingency on funding section. It says the duty of A&R to implement sections 2, the entire program, 3, the report on the management of salt and sand storage facilities, 4, the municipal salt applicator program, and 5, the fee report was contingent upon an appropriation fiscal year 2026 from the general fund for the specific purposes described in sections 2 through 5 of this act. What does this mean? It means that if you pass it out tomorrow and it's sent back to the Senate and they agree with this, or sent to the Senate and they agree with this, that the appropriations bill would need to provide funding for the program to be implemented. If it's not, it would not be implemented in FY26.
Sorry if we pass it out. We did pass H 86 now. They have it. You may have misheard what you said.
Passed by the House.
H 86, that's on the floor tomorrow.
Yes, that's why I thought you said if we passed H 86 out. Anyway, so
If you
tomorrow on the floor, right? Thinking in committee, right? We've already done it here.
Right, so if you pass it tomorrow, send it to the Senate, and they pass it by the end of the session in just say the same form, the program would go in statute, but it wouldn't be implemented because it would not have, unless it was given money in the appropriations reconciliation.
Right. Yeah.
But that's when there's reconciliation, there's not supposed to be something that's included in the conference committee report that wasn't included in either body's proposal, and sometimes in either body's overall proposal legislatively.
You're talking about the conference committee for the budget.
Yeah.
Right.
So if there's no money in either house for it, you would potentially have a issue to object to the conference committee.
However, like we
Do it all the time.
I wasn't necessarily headed there, but okay. That could be. And I think there's other ways throughout the year for it to happen. So I think for me, it's still worthwhile. This is just the reality of where we are in the process. And I understand it. I've spoken to the chair of the Appropriations Committee. I know where, why, and how. And Ella, would you like to add anything to Michael's thoughts so that, you were there, you answered their questions?
Nothing to add. I did have just a question, just fairly new to this kind of language and how the budget works. And I'm just curious about, if money was, like the last couple of years, we've had a watershed for any funds, and that during the off session were reallocated. And then we've got the budget adjustment process later in the fiscal year. And I guess I'm just curious if this language allows for, if there's funding found through one of those, if funding gets moved around for one of those other mechanisms.
During budget adjustment, there's opportunity for that. In the interim, with the limitations on the joint fiscal committees or e-boards ability to reallocate, I don't think they have enough. I can't remember the funding amount, but 400,000 seems high for purposes of what they can reallocate. I think they wouldn't be able to reallocate, especially if they don't have a position they wouldn't be able to hire for that position until approved. So I think budget adjustment's the best option.
It's either in the Senate side on the budget or down the road on the budget adjustment, or the statute needs to get rewritten in a future year to actually be implemented.
Right, and so on the Senate side, I guess that would have to happen today.
Yeah. So, yeah, so the position needs to be created in separately from this bill in order for it. Okay. Representative Austin.
So I'm just wondering hypothetically, how far with the EPA, with Sunny Hollow being a state road in Colchester that is now looking to be at risk for salt contamination, how far we are away from the EPA mandating that it's not voluntary, that it's mandated that this needs to happen? And we'll be in the same place we are now with stormwater funding, and that we would have to fund that.
I can't say how far away you are from it. You are, when there's an impaired water, two things need to be done. You need to come up with the TMDL, which is your budget, which is your goal. And then you need to come up with the implementation plan. They've come up with the TMDL, the budget, the goal, but they haven't come up with the implementation plan. EPA has to approve that implementation plan. And from my discussions with Dana, they were kind of relying on this program to be their implementation plan. So I don't know what that means going into the future.
Do you remember, can I ask you?
Yes.
Do you remember how long it took with the stormwater EPA or the CAPO mandate? How long between there's a problem, it may not get fixed now because we may not be able to implement the plan, and them mandating something as opposed to that it be voluntary?
So the stormwater issues started around 2002. The requirement for the TMDL for them was 2004. There was approval of those TMDLs, but they were hard to implement because they used a surrogate instead of what was really causing the contaminant, causing the impairment. And then as a resolution, the towns with with impaired waters were designated MS4 communities if they were not already. And the stormwater impaired TMDL was brought up into their MS4 permit. There's only one that is not now part of the MS4 permit, meaning that under the MS4, the municipality has to manage for flow into those impaired waters. And they have flow control requirements in those permits, and that's how long that took. 2001, 2002, MS4, 2009, 2010.
5 years?
More like closer to 10.
10 years. Okay. Thank you.
But that was we're going to do this, that's not working. We're going to do this, that's not working. We're going to do this, that works.
Yeah. In the meantime, this is a simpler problem and more urgent for our aquatic life and for our Agency of Natural Resources to have the tools they need to actually try to protect aquatic life from salt contamination.
So I made the point yesterday in the Appropriations Committee that if you don't have a voluntary program and you're continuing to have the same levels of fluoride going into the waters, there are going to be more waters that are impaired. And the more waters that are impaired, the more opportunity for litigation, the more opportunity for a court decision that will put the state in a very difficult position.
Yeah, and the problem goes on and gets worse. As opposed to addressing it
And more
earlier.
expensive.
Okay, thoughts on this appropriations amendment? We just don't have possession of it, but we could do a straw poll on it. And although obviously with a bit of heartache, I trust our appropriations committee and, you know, they will be hopefully looking out for funding for this as the language proceeds, hopefully into statute.
Cool.
You may.
Yeah, I was just wondering if we could modify the language so that if funding, for whatever reason, through the BAA process or any other process didn't come available this fiscal year, what about the next and the next? Is there a way we could put something other than just in fiscal year 2027?
But you can't,
You can't, that's what I was asking. Can you do
Also, the
that?
dates. in
anyway,
the
let's
bill-
let Michael.
The
let's
dates in the
let
bill are also,
So the appropriations process is so annual that you can't
Yeah.
find the future general stuff. You try all the time, but you can just not withstand that. My expectation would be that if this is codified and it's in statute, but doesn't have money, that the agency will propose money in its budget. Most likely is one time to keep it out of base. But that's what I would expect going into 2027,
Or mechanisms to deal with it.
right?
Representative Chafin.
and then in that situation, in early next session, we'd be adjusting the dates
You have
in the
to adjust
bill
the
and
dates.
and everything. Yeah.
Okay.
Thanks.
All right, so let's see, how do I want to frame this question? All those. I'm just articulating the straw poll question.
Gotcha.
It's not an exciting amendment from our perspective. That's why I'm considering whether I should do it in the affirmative or the negative. I guess I'll do it in the affirmative. All those in favor of accepting the appropriations amendment, raise your hand. So I'm seeing 9 in favor, 1 opposed and 1 absent. Or our bill reporter to note. Thank you, Michael.
Am I staying or?
Great if you stayed, I think. Yeah. So next up is H 230 and the latest draft. And you could just remind us of the changes you made after our conversation today. That'd be great.
So the big change that was made was in the effective date. Remember, I had section 6 is the language that does not go into effect until 2027. Section 8 is the existing authority that had previously had language about rules or prohibition on import of amphibians or reptiles. I had misunderstood your intent and I thought you wanted them both to be a 2027 effective date, and you only wanted section 6 to have 2027 effective date. And that was the biggest change between the drafts.
Do members have questions? Still on?
Sorry, it's me. I'll just share with everybody. It was a 9-1-1 vote, which I find a little ironic.
I don't know.
9-1-1.
Emergency still?
Sorry,
Response?
back to 230.
All right, any further questions on H 230 or comments, discussion? Representative Tagliavia.
On section 6, page 6, line 3, I would like, as Fish and Wildlife have requested to see the intentionally taken out.
Others have thoughts on that? Representative Bartholomew.
Well, Legislative Council gave us numerous examples where intentionally was used in statute and that it makes sense. And I think it was our intent to keep intentional in the concept.
Yeah, I think
So
so.
I support leaving it. I think we we didn't instruct legislative council to remove it.
Any other thoughts? Representative Chapin?
I struggled with this one a little bit. I appreciate hearing from the department that they're concerned about how that impacts. I'm less concerned about the workload piece, but the, what happens in the court of law when you have a higher bar. I was really reflecting on sort of our role, and our role isn't to keep doing something that's not great in statute because we did it in the past. Maybe we need to reflect on some of those other hunting statutes that make it legal for you to by accident run over a deer with your car. That seems like there's something wrong with the statutes, not something right. I don't feel good about doing it again. I don't feel good about voting for something that I know doesn't really reflect what we're trying to do for the people of Vermont, which is to protect people who unintentionally take a reptile or amphibian. And so I guess while I am empathetic to the situation that puts both our DEC, our Fish and Wildlife staff in, and potentially make it harder for them to win cases in a civil court. I think in general, I'm not so worried about the civil court situation. And I think we shouldn't be creating law that says it's illegal to unintentionally take a reptile or amphibian. I'd rather think about going back to some of those other
Yeah.
statutes and figuring out that problem that does seem to be a problem.
Representative Sakowitz?
I would agree with that, and I would just add that it seemed like their objection to intentionally in this context was more about more sort of general way that they do things, and not so much that it's really a big problem in this particular example that in practice, but we're probably not going to be seeing lots of cases of people being, cited under the statute that they're violating this, and it's probably really not going to come up very much. But I do think that the concerns around people, there being problems, sort of with unintentional take are potentially big enough that I really would like to see it stay the way it is.
Representative Austin?
Yeah, what's the, to prove intentionality, what is the bar in terms of evidence?
In terms of the evidence?
Yeah,
The standard is that you have to show that they knew or had reason to know and intended the result.
so it's not clear and convincing a burden.
Pardon?
It's not like clear and convincing evidence, that's.
So that's burden of proof. This is what your mens rea is.
Representative Lever?
Do we know if this was a difficult process for the wardens? Are they looking, how do you prove intentionality? Is that what Andrea is concerned
Well,
with?
it's an evidence based standard. You will need to collect evidence, interview witnesses, interview the violator, alleged violator. And then with that factual material, make the case. But remember, you're moving this out of criminal court. This isn't going to be in criminal court anymore. This is going to be a civil violation in front of the Judicial Bureau. You're going to give this person a ticket and a waiver penalty, and they will walk away with nothing on their record. Except maybe in the wildlife database. They will not.
Well, but there's discretion there that if they have to meet criteria to be a civil, they could still be.
Oh, right. I mean, they might have had previous violations. They might have had to do a search warrant. They might have had,
I guess for me, this is about the subject of the bill was the commercial taking, the exploitation of the amphibians, right? And so you're talking about someone who's going out collecting frog legs and eating them when it's not allowed, and it's
Collecting timber rattlers.
and selling them, or, I mean, this is, I know, I thank you for articulating very well, Representative Chapin, why we have our intent and fixing, I think, beginning to consider maybe an underlying, I don't know the right word off the top of my head, but like there's a incongruity in the current way that we're doing this, or it's just not quite right. And so I think we shouldn't repeat a mistake there, and focusing on where this bill started, which was the commercial collection and sale of our reptiles and amphibians. Right, so it's going to be like you just caught someone with 12 turtles. That was intentional. I don't think it's going to be that hard to say like, oh, I accidentally collected 12 turtles. I don't think so.
Tried to sell them.
Tried to sell them. Other questions?
It's where it says, so if it was a person shall not take a reptile unless authorized by the rules, would that cover the intentionality? If intentionality wasn't in there, if in the rules, it was,
Well, the commissioner is going to, has authority that you've delegated to her to allow for certain takings. And so that will be allowed. It won't be a violation.
thank you.
Representative Bartholomew.
There's so much in this bill. I'm confused now. If someone were caught intentionally taking, what happens to them?
Well, if they didn't trigger any of the conditions that would require the violator to be issued a criminal summons, that they will be issued a civil ticket for resolution in front of the Judicial Bureau. The Judicial Bureau, you have an option to pay a waiver penalty, or you have an option to go before the 3-judge panel and make an argument that you are innocent. If you triggered the referral of the criminal division, then it will be up to the state's attorney or the attorney general to prosecute. They sometimes don't. If they do, you will also be given an opportunity to plea. But if you plea, you would then have a criminal misdemeanor on your record. If you don't plea, you go to court, you have the opportunity to convince a judge or jury that you are innocent. If you're not innocent, higher fee, higher penalty, again, most likely criminal misdemeanor on your record.
And penalty means money, fine?
Yes, the default Fish and Wildlife violation is up to $1,000 unless you specify otherwise.
So if I didn't want to go before the judicial process, I could just pay a fine.
Yes, you're given an opportunity to pay a waiver, but if you're in the
A
civil.
waiver, is that the same as a fine?
Yes. I mean, it's called the waiver penalty. It'll be called the waiver penalty in both, but in the criminal division, it's a fine. In the civil division, it's a penalty.
Where I'm going with this maybe my thought process is flawed, but you just described a situation where it's pretty clear someone's caught with a whole bunch of animals and they tried to sell them. It's intentional, easy to prove. If someone is out shooting turtles and is it arrested? Is that the right term? Or
They'll be
cited for it? And then they aren't able to be, because they can't improve intentionality, the case gets thrown out. Have we not achieved the same goal because the person they've been caught, they've been cited, they had to deal with either paying a fine or they're going to court, even if they're found innocent? Is that enough of a deterrent? Have we reached our goal? even if we're not able to improve intentionality for someone who probably was guilty.
I don't know how you could not cut, like if someone's shooting something, that's not intentional, that's intentional.
Well, I mean, maybe that's not the best example, but if there's a question of intentionality where the agency can't prove it.
Yeah.
Person still has to deal with the whole legal issue, either pay a fine or go to court or whatnot. Maybe that's the deterrent, enough of a deterrent.
Yes, I think so. For most people.
So, even if the word kept us from meeting our goal, the end effect might be the same. That's where my thinking is going.
Representative Tagliavini.
Can you define what take means? I seem to remember take does not mean what I think a lot of us think it means.
It means a lot of things. It's defined in 10 VSA 4001. It's essentially the definition that's used at both the federal and almost every other state level. There are some states that distinguish between taking and hunting. Take, pursuing, shooting, hunting, killing, capturing, trapping, snaring, and netting fish, birds, and quadrupeds, and all lesser acts such as disturbing, harrying, worrying, or wounding, or placing, setting, drawing, or using any net or other device commonly used to take fish or wild animals, whether they result in the taking or not, and shall include every attempt to take and every act of assistance to every other person in taking or attempting to take fish or wild animals, provided that when taking is allowed by law, reference is had to taking by lawful means and in a lawful manner.
The reason I ask that does it because of that definition doesn't intentionally make it redundant because of the definition and how broad that is?
No, I wasn't here for the testimony of the department yesterday, but if they were saying that running over a deer is an illegal taking, then it is not redundant to add intentionally.
Say that. All right, further questions? We spent a lot of time on this bill, and I actually think we've improved it significantly in multiple sections, including the one we were just referencing back to the change for in the previous section to the one that we've just now really been spending a lot of time, but the section 5 changes in particular. So Representative North.
That's true. It's kind of more of a question for you. Do we know, given this final version, or what we think might be the final version, that we're something, maybe at least on the schedule was identified for a potential vote today here. Do we know the Department of Fish and Wildlife's kind of final take on this finalish version?
I think you heard their testimony the other day, and this version is essentially the same as what they testified on, and they can speak for themselves.
So they were kind of unhappy with the word intentionally, and they were not necessarily pleased with this whole section 6, the way we wrote it, the way we did. Kind of the inverse of the way. Is that pretty much the entirety of their, as our recollection?
We all heard what they said. I'm not going to interpret it. I stand behind the work we did, and then in hearing what they said, I didn't hear objections really strongly.
As requested, I sent them the new draft and I CC'd you on it.
Yep, thank you.
And the only response I received was thank you.
Representative
To
Tagliavini.
add, I spoke to the commissioner this morning with Governor's Coffee, and the intentionally and some of the wording in the section 6 is not close enough. This is me paraphrasing, but the original bill that was sent is better worded from their perspective.
Right. And I think back to Representative Chapin's comments, and then to say, like, it is our role to actually be the legislative branch and make changes where we see them to be necessary. So totally respect the department and their position, but I also think that particularly in the case of reptiles and amphibians and the lawnmowers and the many ways we interact with them that are unfortunate and hopefully most people try to avoid, it would be kind of irresponsible actually and hard to understand not having intent to be part of this. In terms of explaining to our voters what we did with this work. So, is there a motion?
Do I need to, are we taking a vote?
Yes.
Want to
Representative,
share an observation? When I was walking back to the house the other evening, a woman pulled her car over, around the corner and said, what she got out of her car, walked out to the middle of the road and picked up a frog and helped it across the road. So she actually stopped, parked her car and got out
that's great.
You see it.
to help the frog. Like, thank you. I didn't see that frog.
Yeah.
I tend to choose to drive instead of my husband this time of year because he doesn't see them as well as I do.
Yep, it's important. Give them every leg up they can get.
Well, I've stopped it numerous times in my life and helped turtles across the road. If that
Yeah.
buys me any favor. or anything.
You helped it across the way it was headed.
Yeah, that's where it was going. No, I didn't cruel and to usual punishment, let it get 3/4 of the way and walk it the other way.
Yeah.
Thought you were safe, but.
All right, is there a motion to approve draft 4.2 of H230?
Moved.
Representative Bartholomew moves that we approve draft 4.2. Is there further discussion? I'm not seeing any. Will the clerk please commence to call the roll?
Mhm. Sarita Austin, yes. John Bartholomew,
Yes.
Bartholomew. Rep Chapin,
Yes.
Rep Labor,
Yes.
Rep Logan,
Yes.
Rep Morris.
Yes.
Rep North.
Yes.
Absent. Rep Seckles.
Yes.
Rep Taglia.
No.
And Rep Shelton,
Yes.
Chair Shelton.
And we'll go to finance.
Also known as Ways and Means.
Who's reporting?
Representative Sakowitz will be a reporter of the bill. And I just want to thank you, Michael, for your patience in working through a lot of details on this bill with us. And all the committee also for your interest and care in making it a better bill as it went through the process. So thank you all. We'll go to Ways and Means and hopefully on H230, we'll see it on next week. Is there further discussion? Thoughts right now?
Just, Rep Pritchard has the ability to vote. No,
Not here. Yeah.
but can't vote remote.
No, he's not here. He needs to be on Zoom to vote remotely. He could.
Oh, I see.
He needs to be here to vote on a bill. So,
Okay.
all right, we are actually adjourned for the day. So enjoy